Good morning, this is your Kelso Report for Monday, July 23rd. I'm your host, Clark Kelso. We begin today with the Ninth Circuit criminal sentencing. The defendant in United States v. Rangel pled guilty to mail fraud and money laundering. Based on the sentencing factors set out in Section 3553 of Title 18, the district court imposed a prison sentence that was longer than the one proposed by the parties in the plea agreement, and also in excess of the range recommended by the advisory sentencing guidelines. The defendant appealed, contending, among other things, that the district court failed to provide the proper notice that it was intending to impose a longer sentence, and that the district court improperly took the defendant's inability to pay restitution into account in imposing the longer sentence. The Ninth Circuit affirmed the sentence. On the notice point, the court held that advance notice under Rule 32H of the Federal Rules of Criminal Procedure is not required when varying a sentence based on 3553 factors. As for the second point, the law is clear that a court may not impose a harsher sentence as punishment for a defendant's poverty. But in this case, the district court properly considered the financial impact the crimes had on its victims, including the fact that the defendant was unlikely to be able to make restitution. But the focus was on the injury to the victims, and not the defendant's poverty. So the Ninth Circuit upheld the sentence. Next, we have a search and seizure case. The defendant in United States v. Oliva was charged as part of a drug trafficking conspiracy. He challenged a series of court orders that authorized electronic surveillance by intercepting communications over cellular phones associated with the defendant and his alleged co-conspirators. Now, in particular, he alleged that the series of orders constituted an illegal roving wiretap, whereby the cellular phones were transformed into roving electronic bugs. The Ninth Circuit, while agreeing that the government would have to seek special authorization for the use of a new technology, essentially converting cellular phones into roving bugs, the Ninth Circuit panel held that nothing so sophisticated was involved in the orders that had been secured to monitor the defendant. Instead, the district court found, and the Ninth Circuit agreed, that the orders were intended only to authorize standard interception techniques, and the government didn't do anything more than that. Now we have a couple of habeas cases from the state courts dealing with parole. First, the petitioner in In re Batty had previously been up for parole as recommended by the parole board, but Governor Schwarzenegger had reversed the board's decision. Subsequently, he was granted parole and released when Governor Brown took no action to reverse the board. Well, he wanted to continue his habeas challenge to the earlier reversal by Governor Schwarzenegger, arguing that time spent in custody after Schwarzenegger's wrongful reversal should not be credited against his remaining time on parole. That time in custody should be credited against his remaining time on parole. Well, the 4th District held that the petitioner's release mooted out the prior controversy. The court explained that it rejected the petitioner's theory that before his parole release took place on October 7, 2011, the period of his prison custody could somehow be segregated into portions attributable to the board's grants and/or the governor's reversals, and individually evaluated to support the issuance of any judicially awarded credits. Instead, according to the 4th District, he was in lawful continuous custody on his life sentence throughout, and he received parole consideration to determine his suitability. The inevitable delay among the various proceedings did not convert his lawful life imprisonment sentence into unlawful custody. And even though he was able to gain several grants of parole, they had not yet become final when the events complained of had occurred. Next, the petitioner in re Davidson had been convicted of second-degree murder based on his driving while intoxicated, resulting in a collision in which the driver of another car was killed in 1996. The Board of Parole Hearings denied parole to the petitioner, instead ordering a 3-year further period of incarceration. The Superior Court granted the petition, concluding that there was no evidence to support the board's decision given the petitioner's clean record in prison, his participation in Alcoholics Anonymous, Bible classes, vocational training, his earned certificates, his college class parole plans, his family support, the fact that he was now 60 years old, and his acceptance of responsibility for his commitment offense. Well, the Second District reversed the Superior Court and affirmed the board's denial, concluding that because he had clearly been an alcoholic up to and including the night of the auto collision, his spotless record in prison did not entirely wipe away the risk that he still might pose to the public, notwithstanding the fact that the petitioner had not had a drink since 1996. It seems to me the Second District has gone a little too far in this case, essentially holding that anyone with a drug or alcohol addiction whose commitment offense relates to the addiction can always be denied parole, irrespective of the alleged success of any drug or alcohol treatment program or other factors. Once an addict, always an addict appears to be the Second District's rule of decision. Finally, an interesting search and seizure case. Warrantless searches of residents are, of course, presumptively unreasonable under the Fourth Amendment to the United States Constitution. But police performing an in-home arrest may conduct a limited search for their own protection, known as a protective sweep, under certain circumstances where they have a reasonable suspicion that there may be a dangerous person in the area to be swept. In People v. Werner, the 6th District held that a warrantless search of a residence after the defendant had been arrested just outside his home in the late afternoon, following a report of a domestic violence incident, was an unlawful search, because there was no articulable basis for believing that the residence posed a risk to the officers. The mere abstract theoretical possibility that someone dangerous might be inside a residence does not constitute articulable facts justifying a protective sweep. So the court reversed the conviction, which had been entered on a plea, and remanded, so the parties in the court could determine whether there was anything left of the prosecution's case. And that's it for today's Kelso Report. Have a great day in the law.